Joining me now is Bruce Gibney. He is the author of the book, The Nonsense Factory. I like it already. The Making and Breaking of the American Legal System. Interesting. All right, Bruce, welcome to the Young Turks.
Thank you for having me.
No problem. You're an interesting cat. You're a venture capitalist. You're a writer. You've invested in some of the most prominent and successful companies there are. And you're obsessed with the legal system. All right, I like that too. First, why do you think the legal system is so dysfunctional?
So the legal system is fundamentally a cooperative endeavor. All parts of it have to work together in order to produce a sensible product. You know, Congress has to write laws that the bureaucracy can interpret, and the courts have to interpret the laws and the rules that the bureaucracy writes, and the president has to enforce the results of both. So for any of that to work, all parts of the legal system have to understand each other, and they don't. And the result is that we produce an enormous amount of dysfunctional garbage. Judges, for example, say they know how Congress works. The Supreme Court hasn't had a legislator on the bench since O'Connor retired. There have been empirical studies that show that all these magical canons of judicial interpretation are actually disregarded by people in Congress, so they don't know anything about them. So, and this goes down all the way through. If you've been a client, for example, you'll try and get a straight answer out of your lawyer. You'll be bounced around to 6 different departments. You'll get an enormous bill, and it'll come back with an "it depends." That's just not an acceptable way for a legal system to work. What we need are clear, reasonable rules that the people who have to obey them can understand. And presently, we don't even know, for example, how many crimes there are in the United States. There's actually no unified federal criminal code. I can tell you more or less that everything is criminal, so we're all criminals in the legal system's eyes. I think there's something pretty screwed up about a system that condemns every citizen of a self-governing republic to the status of being a crook.
Yeah, while the biggest crook sits in the White House. Bruce, the problem is fixing it, right? So I went to law school and I took one class that I thought was really interesting where they asked us to write legislation. And you realize when you're going through that process how difficult it is and how every word can be misinterpreted or has some vagueness to it. Every word, every phrase, every sentence. So when you say write it in plain English, on the one hand, I hear you, brother. On the other hand, there's a reason why they write it that way. It's because they're trying to get rid of as much vagueness as they possibly can. So what's your take on that?
Sure. Well, it just depends on who the rules are directed at. If you were the EPA and you're writing regulations for a public utility that's running a nuclear plant, of course the regulation should be, complicated and technical. And if you're writing a statute that, governs, guns in a glove compartment or trunk, then that's something that the average person who has a gun or in the glove compartment or trunk ought to be able to read. So that does depend. I'm all for subtlety. But it has to be appropriate to the people who are actually reading and have to obey the rules. That's just a basic jurisprudential principle, right? I mean, we wouldn't tolerate, for example, a criminal law that was written in Esperanto because no one speaks Esperanto. That would be unfair, it would violate our basic sense of due process. So yes, of course, we have to have subtlety in the legal system. We also have to have sight of how, for example, even with all this technical language that you're referring to, drafting statutes, very precisely, these attempts at precise drafting have not worked at all. That's why there's so much sort of statutory ambiguity, why there are so many arguments about how we should interpret things at the courts, originalism versus proposalism and what have you. So, at the very least, I think if we can't get the hyper-technical language right, then we might as well have something in plain English. Now, keep in mind, by the way, the law requires the citizens themselves to report stuff in plain English. So, if you're a publicly traded company, you have to report your results in plain English. And quite frankly, if Apple or GE or Google can report the results of their globe-girdling operations in plain English in a form that any reasonable person can read, the government can sort of do the same thing with its rules. I mean, you should have to live by the same standard it applies to us, more or less.
So, Bruce, let's get to some things I think that we can agree upon, but unfortunately, as a country, we have not agreed upon. One is politicizing the judges. So I think it's insane that some judges in this country go through an election where, by the way, money in politics exists. So you could simply give campaign donations to a judge, which is basically bribing them and allowing them to be on the bench by just giving more money to the judge that'll rule in your favor. That's insane. So how do you unpoliticize it? What do other countries do that removes politics from that system?
Most countries have professional judiciaries, which we do not. So, for example, in France, you go to it's judge school. You go there for 3.5 years after you do your standard legal education. The judges themselves select. They provide sort of a roster for the president and his minister of justice to select from, and so even though there is a role for the political branch in selecting judges, the field of candidates they can select from is vetted by the judiciary itself. So in most countries, they think this idea of judicial elections is absurd. But even as the appointments process at the federal level, one of the most alarming things that we've seen in recent years is the fastest way to become a Supreme Court justice is to be an enabler of presidential power early in your career. And so this was the case with Alito, Kagan, Gorsuch, Kavanaugh, and Roberts. All of them worked at the offices of legal counsel at either the White House or the Department of Justice, articulating theories of presidential maximalism. And I think it's reasonable to conclude that that's part of why they became justices. It's the way to become noticed by an administration is to articulate the most expansive possible version of executive power. And that's what gets you on the bench. And the problem with that is while the bench itself insulates you from some political constraints, that's the worldview that you arrive at the bench with. You have to be intellectually consistent. That's how you're predisposed to see things. And I think that's one of the reasons why a lot of the court cases in recent years have drifted towards an expansive view of executive power, why they have tolerated abuses by the executive without the sort of pushback that you'd expect. The court's record actually on executive power is not nearly as encouraging as a lot of people think. And at least with this week and contempt hearings, a lot of people are going to go back to the famous case of Youngstown Tube and Sheet v. Sawyer, where the court said, listen, you can't just seize steel mills on some flimsy pretext, right? A la a trade war with, or whatever else Trump is doing in the past 10 minutes. That was immediately preceded by a case called Land v. Dollar, where the court buckled 3 times to presidential contempt, essentially, by the Secretary of Commerce. And the difference between the two cases is 1952, when Youngstown Sheet and Tube was decided. I think I have that date right. So, and with Youngstown, Truman had already basically lost the primary, and there was really not a lot to push back against in terms of presidential power. Truman was a lame duck. The year before, he was fairly popular. And when he had strength, when the presidency had strength, the court caved. So the court's record on pushing back against executive power is not as encouraging as we're taught in law school. It's actually a much more mixed bag. And I do worry about that.
Yeah, I also think that they raise their hands for the judges that are most likely to give corporations power. So Gorsuch said, yeah, if your corporation tells you to freeze to death, you have to freeze to death in the trucker case. And so Kavanaugh had a similarly vicious argument in the SeaWorld case where he said, yeah, no, you don't get no workers' comp for a killer whale literally killing you. And so if you raise your hand and say, yeah, I will let corporations do anything they want, your chance of getting on the Supreme Court is significantly higher. So this is a totally absurd system. And hence the name of the book is The Nonsense Factory, and I think that makes sense. Well, at least one more thing here about easy fixes. The law doesn't always apply the same to everyone in America, right? I mean, we've got justice is blind as a theoretical concept. But if you say, hey, I didn't know that law, that's not gonna help you at all. But what if a cop says that? Does that help him?
Yeah, it does. So I'm going to articulate a right-wing justification for a very left-wing outcome. So one of the problems with the legal system is it confuses quantity with quality. It's for everything there must be a rule, because a rule is the solution to all problems. So as a result, we have an enormous number of rules in our system. The problem is that the system can't enforce all those rules evenly, and the price that we pay for that is executive discretion, which means that prosecutors charge whom they want, how they want, which means that police arrest whom they want, when they want. And even when they overstep, even when they make an error, the Supreme Court has offered a version of sovereign immunity, qualified immunity, which says, listen, our jurisprudence on searches, seizures, police brutality, misconduct, this, that, and the other, it's just too complicated for a beat cop to understand. Now, by the way, we're going to hold you, the citizens, responsible for all of it. You have to know every single piece of the law, because ignorance of the law is no excuse, unless you're a cop. In which case, we'll say, who could possibly understand all these rules? So why don't we just say, if any reasonable mind could disagree, any reasonable comp would think, well, the law here is confusing and maybe it means this, maybe it means that, by all means, pull the trigger and we'll let you go. So this is the price that we pay for having a lot of low quality rules. Now, it would be better if we had a few high quality rules instead, and then we could limit the amount of discretion that we've invested in the executive. Because the problem with executive discretion is it's no better than the executive who wields it. And presently we know who the chief executive is. That's the president. And that hasn't worked out particularly well in this administration, but it hasn't worked out particularly well in many administrations. I mean, Nancy Pelosi is right. There is a constitutional crisis, but it's not just Trump. The presidency itself is a constitutional crisis.
All right, Bruce Gibney, a really interesting book called The Nonsense Factory. His earlier book, also interesting, was called A Generation of Sociopaths, How the Baby Boomers Betrayed America. So Bruce, thank you for stirring the pot and coming on here on the Young Turks and talking it through. We appreciate it.
My pleasure, thank you.